you agree with me if you have been there. I mean, this place was so stinky, smelling. Check the toilet facility before then, before now rather. And if you go to those places now, you see that some sanitary conditions, some sanitary maintenance have been taking place. You know, by and large, structurally, the Chief Justice and the Judiciary, they're doing very great.
Right.
In terms of even staffing. Okay? I mean, I have been informed and I know reliably that even staff, salary and other things, as a way of motivating staff, those staff motivation and salary, those things have been also worked on and improved.
Okay.
Because you need to have the well-motivated staff to get the job done in the manner you want that to do. But that is just what I would describe as the hardware of the judiciary, okay? Like my brother rightly stated, the software, you understand? That is what the hardware, the structural development, the establishment, the divisions, you know, to get things happen the way they should do. You understand? But let's look at justice itself, the dispensation of justice, okay? The issues having to do with backlog cases. As PRO of the bar, we have had a lot of complaints, you know, having to do with backlog cases and all of that. But probably these are things we'll discuss as we go on to.
Definitely. Let me hear from Alphonsus. So 50-50, you would want to rate the judiciary for 2021. And you've listened to what the Public Relations Officer of the Selling Bar Association has submitted with regards the environment where they operate. It's been given a facelift, and the establishment of specialized courts, the industrial courts, the specialized court for corruption, specialized court to expedite cases of sexual offenses and things like that. Now, your 50% in terms of the actual dispensation of justice, what does it entail?
Thank you so much. And I think what my brother said just captured the 50% we give in terms of infrastructure, and with regards to even the recruitment of magistrates, where we have sitting magistrates in all the districts, because we have not experienced that some years back. We have more judges now sitting, and we have mobile and roaming courts that judges sit up country. And he has mentioned already the salaries, enumeration, you know, and the building itself. So that's what I said, in terms of infrastructure, in terms of policy, in terms of setting the system. He has done a lot, and that is why we gave the 50%. Where we have also that 50%, which is the soft component, what I think, in fact, it could be, in fact, even the hardware could be 51, because the soft component could be 49, because that is where we have the problem. I know we admire the current Chief Justice, but the action and conduct of the current Chief Justice is like our usual proverbs that our old people used to say, that you can take the horse to the stream, but you cannot force the horse to drink the water. So the institution itself, the Chief Justice has done a lot, like taking the horse to the stream, making sure that, you know, hire more judges, magistrates, putting systems in place and whatsoever, but you cannot force the horse to drink water. In other words, even when there are cases assigned to judges or magistrates, it is not the Chief Justice that is going to sit in that place. So the mentality, the perception of the individual judges and magistrates, that is what I think we have the problem with in the area of dispensation of justice. Because the decision of the magistrate, the decision of the court, the Chief Justice has nothing to do with it. He cannot direct, he cannot suggest, he cannot even control what the magistrate will want to do or the judge will be doing in the area of arbitration of justice. And so we are seeing where they are improving, the infrastructure, but the soft component of the justice system is also challenging. And I can give some instances. At least we will give credit to the entire justice system in the history of this country for a principal accused person going through a treason trial, and he was acquitted and discharged. In the history of this country, it has never happened. So that is kudos to the judiciary. Nobody has ever been identified or accused for committing treason as the principal accused person, and that person went scot-free.
Works out.
It has never happened. But that is a kudos. But the challenges we have, and I will start with one incident that occurred in Kabbalah, because my brother rightly mentioned the issue of sexual offences court, which is very good. And we appreciate even the president making sure that the issue of sexual penetration, rape, should be addressed properly. But are we putting a scale in terms of making preference as to which cases should we prosecute, or which cases we need to prosecute or we don't need to prosecute? And we have seen I'm bringing the one in Kabbalah and the one in Bond, and I will relate it to the Kamarimba situation, so that we get people who will be watching, try to get the scenario, what I want to make. When you look the situation in Bond, that one involved a sitting permanent chief of an alleged rape matter. That matter was investigated by the family support unit. We follow up that. In fact, we took the matter to the police. They investigated. They provided all their files. They sent that file to the law officer department, to the office of the Attorney General Minister of Justice for legal advice. To date, that file had never seen the light of the day. What happened? They said that matter now has been taken to the ECOWAS court. The next thing, there is a case that has been investigated by the family support unit. The matter was taken to the magistrate court for PI, and it was committed to the High Court. What happened next? Was a call from the AG's office. And the file was taken away from Kabbalah and brought down to Freetown, and to date, nothing. And the gentleman that allegedly committed the crime, a very serious crime, you sexually penetrated the girl, and the girl was pregnant, you do a criminal abortion, the evidences are there, and we saw where
the state
compromises that, because the person is a very strong person with the government, the powers that be, and is a close ally to the party itself in Kabbalah. And you see how they compromise. Then look the situation of Kamaremba. So what I'm now trying to bring, in as much the Chief Justice is doing a lot, or the judiciary are trying to rebrand the face of the judiciary. How can we brand the face of the judiciary when we are conducting what we refer to as selective justice? That is not rebranding. It is not rebranding. And so if justice for one is justice for all. And so if we are saying we are now selecting justice, then we are not doing justice to the people of this country. And interestingly, the judiciary is the third arm of government.
So I'm tempted to ask this question. Both of you have submitted that given the Chief Justice has done tremendously good work with the judiciary. The establishment of specialized courts, the recruitment of more judges assigned to every district. But now you are raising cases that deal with perversion of justice and selective justice.
Of course.
Now, if we are saying, for example, that the state is compromising through the office of Attorney General and Minister of Justice, who is acting on behalf of the president, and the president appointed the Chief Justice, I'm looking at the correlation of these offices and how, at the end of the day, when they adjudicate matters, how it pans out. You mentioned the Mohammed Kamarimba Mansari issue, which many have attributed to it being a political witch hunt, instead of him actually answering for the matter he's charged with. the sexual offenses charges. He's been held for over a year, and even when a specialized court was established to expedite the process. So where do we put the actual dispensation of justice in 2021 from the judiciary?
I think one of the overwhelming cases, that is why I made mention of the treason trial.
Right.
That is the only time we say, the judiciary has done justice to the people of this country, in the history of this country. The moment they tag that word to you, treason, you have been accused of treason, just get it for sure that you are gone. Mm-hmm. But we have seen it, the principal accused was let go. Somebody was telling me that was a political gimmick. Well, we will not take it that way, because we are looking at it from the angle of
an independent judiciary.
Independent judiciary. We do not believe that there were political compromise on that, because the judiciary, they do their own job, and they have the jurors, they did their job. But the concern is that, as stated earlier, why the Chief Justice has, he has a very strong vision to transform the judiciary. But the question is, if the captain has, very ambitious plan, what would be the support from the lieutenants? The Chief Justice cannot do the entire judicial system. He cannot deliver justice as an individual. He needs the collective support of even the judges and the magistrates that are handing down judgments. Because when they have down judgments that are free and fair, the kudos goes to the Chief Justice. But if they are giving judgment, or even they are manipulating on cases, no matter what the effort of the Chief Justice, it will be undermined.
Let me bring in Michael. Let's go to the software aspect of the arguments you were submitting. Now, Alphonsus has helped us to put the conversation into context, where you have, the state choosing what cases should be prosecuted and what cases should not be prosecuted. And he has clearly mentioned a case from Kabbalah. File was brought into Freetown and disappeared, missing in action. And just because of the link the accused has with the ruling party. Whilst you have Mohamed Kamarima Mansari, who is an opposition politician, but standing trial for same offense committed by that pro-government accused person, but he is languishing, granted bail, and the master registrar is saying, no, he has not met the bail conditions.
You have to be very careful when you make a conclusive statement, such as there is selective justice.
Questions are being asked.
You understand? When you say some cases are being tried and some cases are not being tried.
Right.
You have to be very careful because they need to be backed by evidence. The law has two major layers, one of law and one of procedure, okay? And they must work like husband and wife, you understand, to achieve something. For a matter to be charged to court, it goes through a lot of procedural surgery, okay? And the Office of the Attorney General and Minister of Justice, I hold no brief for them. And I thought it should have been appropriate to get somebody to answer questions of this nature for them. Neither do I owe a brief for the Office of the Chief Justice and the Judiciary. That is why we are expecting a class to be here.
Right.
But there are certain things a certain case will have to meet, certain investigation, you understand? That is one reason why investigation done by the police are sent to the Office of the Attorney General and Minister of Justice for advice. Otherwise, they will only send that to court. You understand? You don't go to court to lose matters. You go to court to win them, okay? It's not about just going to court. When an incident happens, the police are supposed to investigate. For example, there is a theft situation here. They will come for all of us here. Under the circumstance, we are being suspect. The police will investigate. Having investigated, you realize that they will release some people, and they will not release some people. Okay? Once you are charged, you become an accused. Your name changes from a suspect to accused. When police send matters, having investigated matters, such matters are sent to the office of the DPP or the Interior Minister of Justice, right? They look into it and review the entirety of the evidence before them. They said the procedure is that they have the right to advise as to whether such a matter should go to court or not to go to court. The benchmarks as to what is required for such a matter. So it's not about the fanfare, it's not about the sensation. Some matters, even before they are investigated, people are convicted already from public perception. You understand? That is not law. Most of them, people don't even know the details involved. You know, every offense has its elements that are needed to be proved or disproved.
The application of the law, we can go into the details. The procedures and things like that, we can go into the details.
So when the Chief Justice or the Office of the Attorney General and Minister of Justice has not charged the matter to court, it is but proper that these civil society activists could, if they like, inquire from them, why has this matter not charged to court? Probably a proper answer to them. We give them reasons why.
When we talk about selective justice, it's a monumental crisis in this nation for many millions.
I'm not here to justify that.
No, I just want to ask a question.
Yes.
I just want to ask a question. When we talk about selective justice, for many it's a monumental crisis in Sierra Leone, where we've had stories about people. If you're close to the powers that be, now both case. When you do certain things, not both case, but when other people do those things, the law would definitely come into play. So he just mentioned, a matter that has been investigated, sent to the magistrate court for also preliminary investigation, and committed to the High Court. Where is that case?
You just matter be committed to High Court.
He mentioned.
Good. So
where's the matter? You had him. The file, the case.
The matter said the matter has been charged to the High Court.
That's what he said.
Okay, there is also a procedure involved when matters are charged to the High Court. Okay, they can be assigned. You understand? They will always call over. And whenever there's a call over, such matters come up. And they are assigned. Okay? I think the proper thing is to know from the time the matter was committed to the High Court unto date, what has become of the matter. I am sure that could be answered.
He said the files are nowhere to be seen.
How did he arrive at that?
Because the cases are not coming up.
So because
the accused persons are out there enjoying because
he is a right activist.
Exactly.
You understand? I wish Elkas was here to answer some of these questions. Like I said, I speak from the bar.
Exactly.
No, right? I cannot tell you exactly what is happening within the judiciary. So maybe the PRO would have...
The bar plays a crucial and integral component.
The PRO would have been so instrumental here to tell us
what is
happening with files as alleged by my fellow discussants here this afternoon. You understand? But what I'm trying to say is this. You understand? There is always a procedure.
Right.
Every given matter, you understand, cannot be the same as another matter because the elements or the issues involved are not the same. Okay? So, if a matter has been charged for preliminary investigation at the magistrate court, and the magistrate court has accordingly done its investigation within the confines of its jurisdiction, and the matter has been committed to the High Court, it is always the case that the Chief Justice will always assign that matter. But if you have matters that have not been assigned, it is but proper that such matters are taken up with the office of the Chief Justice. The Chief Justice is an open person. He's approachable in this country. Everybody will tell you that the Chief Justice is approachable. Okay? So, I mean, as a right activist, these are some of the things they do. Like I said, I do not owe a brief for the judiciary. Right. You understand? I cannot confirm allegations that that matter in particular, you know, has not been assigned, or even whether it has been assigned, I mean, credence has not been given to it, okay? Right. But what I will tell you is that there are always procedure, and those procedures as sanctioned by time. In addition to the camera member issues you raised, right?
Yes.
I did not want to talk on a case-to-case basis, you understand? I wanted to look at it from a generic point of view as to the software, you know, activities of the judiciary, which has to do with dispensation of justice, backlog cases, trial, and all of what my colleague here has just stated. And I wanted to talk about it from a generic point of view. But I have a reason to talk on the Kamaremba issue.
Go ahead.
Kamaremba has been granted bail. We took out time as the Bar Association to investigate when the issue of Kamaremba became so much sensational in this country, haven't given bail, and he has not been, met his bail condition, right? I personally, had an interface with the master and registrar, and she told me they are ready to give Kamaremba bail. You understand? But Kamaremba has not met his bail conditions. That is what she told me, and I told her to explain further. They asked for Kamaremba's passport. Okay, the passport, according to the chief, the master and registrar, he tendered. It's a passport he has never used. It's a Sierra Leone passport he has never used. Okay, I think obtained as recent as when it was required. Okay, they asked him, you have been traveling abroad and back.
When it was required?
Yes.
And the man was in prison, so how was the passport issued?
I don't know.
By the immigration?
I am telling you what the master told me, that Kamaremba has not met his bail condition. We are concerned as members of the bar. We are concerned as executive members of the bar. So when this issue came up, we confronted the Chief Justice. We also approached the master and registrar, okay? Their explanation is that Kamaremba has not met the bail condition. We probed further to inquire how comes Kamaremba has not made his bail condition. Principal, among other things, is his passport, which he tendered, okay? You and I agree, we agree with the master and registrar that Kamaremba has been traveling here and there is a passport which is bearing some stamp or some kind of use.
According to it, got burnt in a fire incident.
According to the Chief Justice, according to the master and registrar, you understand? She said they have nothing against Kamaremba. If Kamaremba passport suffered in a fire accident, some police evidence should have proffered. In my estimation, his lawyers, if you have an accident, there is a fire incident, you suffer. As of the time, spontaneously as of the time, some police entering, justifying those kind of things would have been produced and tendered.
Without cutting you short, let me just welcome the Director of Communications for the Judiciary of Sierra Leone, Elkas Sannoh. Good evening and welcome to the conversation, Elkas.
I'm happy to be here.
All right, thank you. So before I bring in Elkas for his precursory remark, let me ask you this question. In Sierra Leone, almost everything is being branded. The judiciary, the media are just like the Bar Association. Today, people will tell you the current executive members of the Sierra Leone Bar Association are pro-SLPP. The previous, they will tell you, oh, they were pro-APC. That is how things are in Sierra Leone, and people can tell by actions or by association. So, the allegation is that there is this heavy political hand influencing the work of the judiciary, especially when it comes to cases that have to do with politicians. Mohamed Kamaremba Mansari not out of it.
I cannot dismiss that outrightly. You understand? Because we are all human beings. But I cannot justify it outrightly equally because I have no evidence to back it.
Right.
Okay? We are all human beings. We have friends. You have friends everywhere.
Right.
The tendency for people to call their personal people on personal matters, you and I cannot see.
Right.
You cannot say it is not happening. But when you want to say it is happening, you must have evidence to justify the same. Okay?
Right.
What I would say generally,
go ahead.
In everywhere in the world, there is the need for the judiciary to be independent. There is the need.
And do you see this judiciary independent? This judiciary?
In my estimation, if you want to have my opinion on this,
yes,
I think the judiciary is enjoying some ample independence
Some
as
ample.
compared to other regimes I have witnessed.
All right.
Okay? Ample independence to do the things they're supposed to do. You understand? I am not saying outright.
Do they have operational independence? Do they enjoy operational independence? But from your perspective, as an integral group within the justice sector in this country, the bar association is very integral within that sector. From your estimation, do you see the judiciary enjoying an operational independence?
The judiciary is an independent institution. And I think they are operating within the independence accorded to them.
All right.
To me, they are autonomous. Because we do not have the president.
By law.
We do not have the president forming the judiciary. We do not have the executive members like the ministers forming the judiciary. Neither do we have the members of
by default, the president forms the judiciary.
By default, yes, in some sense,
right.
I agree.
Yeah.
In some sense, right? Or by the operation of the law. But like you rightly said, so ceremonial. You understand? They ought not to interfere. The president ought not. The ministers ought not. You understand? Members of the public ought not to interfere with the judiciary.
You have the Attorney General, who is very critical as well in the judiciary.
You understand? So I cannot justify, because I don't have evidence to suggest that there are political interference. You understand?
Yeah.
But I will tell you that it is always possible for some political interference into this dispensation of every judiciary anywhere in the world.
Okay.
You understand? But I will further state that for this judiciary, I have known as the public relations officer, compared to other judiciary I have witnessed in this country.
It's the same judiciary.
I'm coming. You have just laid the basis that judiciary under the previous government and judiciary under this government.
They are leaders.
I'm speaking from you. I think they have enjoyed some ample independence.
Right.
They have enjoyed some ample autonomy. You understand? To carry on the things. Otherwise, like my colleague rightly stated, in the treason matter, Paulo Conte was going to be convicted. If it were a judiciary that was remote controlled by the politicians.
Okay.
Because you and I will agree that every other politician in the current dispensation will want Paulo Conte to suffer because they're a political opponent. You understand? But the judiciary is too as an arbiter and ensure the justice was what it was. They did not find him guilty and he was discharged. He rightly said, in this country, there is hardly any moment or history that will suggest to you that somebody has been charged for treason and the person walks out free.
And another school of thought holds
you understand?
That was just a political gimmick for the current dispensation to score goals.
Whether it was political gimmicks, you and I don't have any justification for that. But the fact that the politicians of the day wanted Paulo Conte behind bars, yet the judiciary stood as an arbiter, you understand, and set him free. In my estimation, what else will make the judiciary independent, if not these things?
Let me hear from the Director of Communications of the Judiciary, the official mouthpiece. So, Elkas, first, it is but fair to have an overview of of basically the judiciary assessing itself for 2021. What would you say about the judiciary for 2021?
I am happy to benefit and to be part of this conversation. The reason why I am saying this is because over the years, the judiciary has been castigated or has been bashed by civil society, by the media, either for the wrong or the right reason. But now that we have a very foresighted Chief Justice who has opened the space and allow conversation around the judiciary, I think that's a very laudable initiative.
Your activities are no longer shrouded in secrecy?
No way. The reason why this is happening is because this is the 21st century. And aside from being the 21st century, the Honorable Chief Justice, His Lord Chief Justice Desmond Babatunde Edwards, believes his leadership, especially that has to do with the operational activities of the judiciary, should be accountable and transparent. And you cannot talk about transparency, accountability, without taking the judiciary to the people, without coming to the media and explain what obtains either during court proceedings or the operations of the judiciary. So far, when he assumed that position, the current Chief Justice has made unimaginable successes since independence, successes that are second to none.
What are they?
One, for the very first time in the history of Sierra Leone, since independence, for us to have magistrates across every district. This is because he believes justice should not only be limited to Freetonians, but as long as you are citizens of this great nation, you deserve justice. Therefore, there is need to ensuring that we take justice to the people.
How do you recruit?
We use that I'll say again.
How do you go about the recruitment?
We allow competent Sierra Leoneans to apply, go through the normal process.
Is that made public?
Yes. Application is there to the effect, go through all the due processes. And at the end of the day, when they were recruited, they went through series of professional trainings. Not that they are not professionals, but to actually reposition their mindset that they are coming now to serve the bench, rather than either being on the defense or whatsoever. Now that is just one. We have also recruited and deployed judges for the very first time in places where there have been no sitting judges. For the very first time, for a court to sit in places such as Falaba, Guinea border, Kwendu, for the very first time. And people came out in their numbers, praying for the current Chief Justice and praying for the current government for supporting the judiciary. We are not there yet. But what is very much important that has made this judiciary to become very enviable is that this is the very first time for people to live outside their own jurisdiction, to travel to come on study tour to Sierra Leone. This is something we must tap ourselves for. We must commend ourselves as Sierra Leoneans for being part of this great nation. For people to leave Gambia and other parts, Nigeria, Ghana, to come, said what? We are coming on a study tour to see the magic behind the rapid transformation under this leadership in just 3 years. That is just one. Let me look at the administrative setup.
Go ahead.
It's very shameful, but it's always good to say this. When the Honorable Chief Justice took over, the current judiciary had only 2 university graduates.
Yes.
2 university graduates. When they came, there was nothing like, so it's very much shameful. There was nothing like court operations manager. There was nothing like human resource manager. So you ask yourself, how people were being recruited at the judiciary, a third arm of government, but they were still staff. So how were they recruited? For the very first time when he came, he said, in as much as we are talking, people are trumpeting the administrative justice, which is the foremost responsibility of the judiciary. But that aside, there is need for administrative reforms. And how do you use administrative reforms to enhance the democratic good governance of the judiciary? You need to bring competent Sierra Leoneans to serve in position of trust. That's why for the very first time, we have competent Sierra Leoneans who are serving in those senior positions, like the human resource manager. This is the very first time we have a procurement manager in the judiciary. This is the very first time we have court operations manager. And mark you, he did not lose sight of the very fact that women's empowerment is very much integral in the administration of justice or whatsoever you are talking about. That is why, for the very first time, we have created the opportunity or more platform for women to come on board more than any other administration can do. We have the master and registrar, who is a woman. We have the registrar of the Court of Appeal, is a woman. The fast track court registrar is a woman. We have the human resource, is a woman. So we have competent women at the helm of affairs at the judiciary. This is very much important.
These are parts of what Michael refers to as the hardware. What many Sierra Leoneans look forward to or have interest in is the actual dispensation of justice.
Samuel.
I understand, and I know definitely the environment is very important to delivering that. I understand. I know, I mean, it's part of the entire judicial ecosystem if we are to get things right. Let me ask this question again that I asked Michael earlier about the operational independence of the judiciary. I'm asking this question against the backdrop that a friend of mine was telling me the other day, who told you that the judiciary is independent? When you have the Attorney General and Minister of Justice, who will just walk into any court? I mean, depending on what the case or the interest can nullify that matter and just... So take me through the independence of the judiciary.
Let me say this.
Go ahead.
There is nowhere in the world that we have absolute independence. Nowhere in the world. Even advanced jurisdictions like the America, the president appoints Supreme Court judges.
Agreed.
This is because we have what we call fusion of power. Fusion in the administration or in administration of service delivery. That is why we have the three arms of government. The executive cannot function independently without the support of the legislative arm of government.
So does that mean in this case, the executive controls the judiciary?
No, that's not what I am saying.
What are you saying?
Allow me to say this. Now, the Australian judiciary is a creature of the Australian Constitution, Act number 6 of 1991.
Right.
And it states in section 120, subsection 3, it states that in the exercise of its judicial function, the judiciary is subject to nothing, only the law or the Constitution. Moving forward, the current judiciary, the opposition parties have won more cases than the ruling government. The evidence is there. We have, let me even highlight some of them for Australians to understand that I am not just talking out of figment of imagination, but evidence. KKY, Kande Koleyom Kela, he was on 98 on different radio stations, on televisions, commending the current judiciary. He said, this is what we have been clamoring for. It means what they have been clamoring for. There is now glimmer of hope that we are not there yet.
Because he won. Was that the case? Because the case was in his favor.
That means.
Go ahead.
That means it is it is coming from the opposition end. In those days, I was not at the judiciary, but my service in the media over a decade. You don't even think about that. You don't even think about that. The cases are there. They are enormous. Then, Samoa Kamara. Samoa Kamara won his case. He, somebody from the ruling government petitioned the candidature of Samoa Kamara that he is a Tutsi
holder
or whatsoever. He won that case and they commended the judiciary. That means the judiciary. That's the operational independence of the judiciary. And even Sidi Tunis was here at 98.1, commending the current judiciary for helping to improve the democratic credentials or the democratic, to build the democratic core values of the judiciary.
These opposition politicians again, these opposition politicians who you were saying are praising the judiciary are the very ones as well condemning the judiciary. Go, for example, Sidi Tunis, of course, in the recent EU report that says, of course, there is significant decrease in trust in some institutions, and the judiciary was one of them. And they cited the removal of 10 MPs and the judiciary's elected MPs of the ruling SLPP. These are the same opposition politicians.
Let me leave the reason why I brought in the opposition political parties.
Right.
It's because they are very much fundamental when you talk about building our democratic credentials. And that aside, the dynamism and complexity around the administration of justice is just what you have highlighted. How? If a matter is between Mr. A and Mr. B, and Mr. B is unfortunate to win that matter, you have the worst judiciary. If Mr. B wins, we have the best judiciary. So that means human beings are very insatiable. But what we are doing is that we tie our operations to the constitution. What is very much important to us is that we want the Sierra Leone judiciary to be an envy within the sub-region, wherein people will come within this, people will leave their jurisdiction to come on study tour. We want, like we are doing, to digitalize the Sierra Leone judiciary for the very first time.
This dream is very great, and all of us would love for it to come into reality. We really, really love this dream, for it to be independent. But by default, almost every institution in this country is politicized by default, like the Sierra Leone police that has a police council. The chair of that council is the vice president. You have the internal affairs, so by default it is politicized. Like the judiciary, having the attorney general and minister of justice playing that crucial role in the judiciary, by default is politicized. And the president himself appointing the chief justice is politicized by default. And you have to feed through that ministry when, I mean, your budget and all of that, you have to feed through the Ministry of Finance and things like that. How do you hope, and when, for many Sierra Leoneans, the politics we practice in this country is so toxic that it has to be in my favor or let it go. So how then do you ensure that this dream, this quest for for operational independence and giving trust to that crucial body is achievable? How?
Now, also, you hardly see somebody who comes up, a particular person coming up with evidence that I was there when President Bio called, or I was there when this minister called this judge to remote control the judge. You don't see that evidence. People, one thing I have observed is that either out of ignorance or because people have sentimentalized their thinking to a very large extent that even when they are seeing the truth, it is difficult to swallow the truth. Now, in regard to the Sierra Leone judiciary, so far, we are not there yet. That I must confess. We are not there yet. Justice everywhere in the world is very expensive. But to say because there is this appointment from the president, that means the judiciary is not independent, that serves as a roadblock in the operational activities of the judiciary, I disagree. Recently, or can I say recently, before the ascendancy to power of the current president of the United States of America, Joe Biden, you will agree with me that Donald Trump appointed one of those Supreme Court justices. He made that appointment.
Where system works.
Let me tell you, system works or system don't work. Sierra Leonean human beings, not robots, human beings are in charge of the day-to-day operations of those institutions. And I will always say this, I will continue to say this. If you look at where the judiciary, where we are coming from, and just 3 years, what we have achieved so far, it makes me to continue to salute and give the current Chief Justice a standing ovation because of his leadership desire to ensuring that we have, when you talk about the administration of justice across Sierra Leone, across the country, to him, we are not even, he's not bothered about your religious background, your social status in society, your political affiliation. What is important to him as the Honorable Chief Justice and the entire management of the Sierra Leone judiciary is that we think Sierra Leoneans deserve justice.
So let me bring in.
As I end,
okay, conclude.
As I end, I want to continue to reassure Sierra Leoneans that we are financially constrained, but when we have the financial support, I must tell you that next year, when we are coming, we are being re-energized to ensuring that the Sierra Leone Judiciary will change the perception.
Who pays the piper calls the tune.
No,
That's a cliche.
Perception and psyche of every Sierra Leonean.
That's a cliche we all know. That's a cliche we all know. And we live in a society where the president does not need to pick up his telephone to call the Chief Justice that I'm interested in that case. I've had a conversation with Francis Ben Kaifala.
I have never witnessed that.
I have. Obviously, that's what I'm saying.
I have never
That is what I'm saying. The president does not need to. The minister does not need to.
We've never seen that.
I have had a conversation.
No judge has ever reported that.
I have had a conversation with Francis Ben Kaifala. One thing he clearly stated was sometimes political appointees feel obligated just by the appointment that this panel appoints me, I for do all thing for please whether or not the president is interested in that or not, and the president wants things to go the right way, just because he has appointed me, I now feel obligated that this I know will let the park call myself. I need for do make the park happy. And these are the things that happen in society. Many people have submitted or advanced arguments around these things. What is very critical, why I mentioned that, is because Alphonsus mentioned that there are cases, for example, the sexual offenses model court. You've dealt with so many cases. I mean, you've expedited so many matters. But he mentioned some cases whose, the interest, a case from Kabbalah, a sexual offense matter, I stand to be corrected, from Kabbalah, that was transferred to Freetown.
No.
Go ahead, please make that submission so that he understands better.
Okay. Anyway, let me just do that because
Please.
I'm thinking of something to. Because I was wanting to say something to what you have been.
You can go ahead.
The matter of Kwenadugu or Kabbalah, to be precise, is an issue of soliciting sex from a young girl, criminal abortion, and the matter was charged, investigated, and charged to court, to the magistrate court. The magistrate court did the PI, and it was committed to the High Court. The first appearance in the High Court, the matter was in the High Court now for the judge to prosecute, and where we had an information that they received a call from the AG's office that the file should be sent to Freetown. And to date, nobody knows what is going on. The suspect is working. The accused is a young girl. That young girl could have been dead by now, and yet we are talking about sexual penetration, moving mobile courts. So are we doing, and I brought that case because I wanted to do the link
with the
Kamaremba case. So are we seeing a situation where the government or the judiciary is cherry picking or deciding this case is what we are going to prosecute, or they have preferences or selective justice? And so that was why I brought that incident.
So note that you respond to it.
You can take that, you can follow up on that. And even some of our colleagues in Kwenadugu, when they are raising their voices on that matter, they were harassed, they were intimidated, they were targeted. We have all the recordings when they are threatening them. In fact, that
who
some of them? Some community members that are supporting the alleged perpetrator. And the alleged perpetrator is a very close friend to the deputy minister of justice. And in fact, he's among his campaign team. I will not hesitate to say that. And that's why we are raising concern, because if the government, I always keep saying this word, each time government raise the voice or make a pronouncement that he wants to address the issue of women and girls, we are 100% in support of the government. But you don't just say the word, but demonstrate it. So the sincerity of government also depends on how even the judiciary also address the issue of justice. And so that is it on that matter. But let me just quickly, because I appreciate we are making reference to to the Constitution that relates about specifically at the independence of the judiciary. And I will still confess that the judiciary is the only institution in this country that is not answerable to the president. That is not answerable to, even though it is the president that appoints the Chief Justice, they are answerable to the Constitution. Everything is the Constitution. So which means we should not see a scenario where the judiciary, you are only answerable to the Constitution, not to an individual, but to a Constitution, to a document. And the primary responsibility of the judiciary is to give meaning to law. And you give meaning to law by interpreting it. And you take your reference, and where you have your power and your legality of existence is the Constitution. But you know, to a greater extent, and I had him struggling. It's just like the situation where we had this issue of corruption in Parliament. They will never tell you that they are corrupt. They will, even if you say where is the evidence? You know, but to be sure, we are all Sierra Leoneans. I have brothers and sisters that are in Parliament. We can sit together, we discuss. Because we are all brothers. And we know how to operate. But when a member of Parliament raised the issue that we are corrupt, we saw what happened. But indeed, it is happening. And we saw even the people's perception about Parliament, about corruption. And so the issue of saying, maybe the president will not call, or minister will not call the judiciary, I can understand your role. You will not say that. And nobody will say that. And nobody will say we are bringing the type of evidence. But what we are saying, if the judiciary is not doing selective justice, the case of the young girl in Pujong in 2019, in Babdongobabulo, Bond district, that involved Chief Kabakaba Toka. We brought that matter. They investigated that matter. We follow up that matter. I saw all the material evidence in that file, even before the file was taken to the AG's office. At that time, it was the Priscilla that was the AG who raised our voices. That file never saw the light of the day. And that's why I was admiring my brother when he was talking about there is law, there is procedure. We are all aware. Some of us have not, we are not involved in human rights work yesterday. I started human rights work way back in 1982. We established amnesty in Sierra Leone in this country. Way back in 1982. So I'm not a new person in the field of human rights. And at least when doing my own human rights, I have not gone through law, but I also read law. So at least I know what I'm also doing. But the fact is that we are not doing anything to say because I had them say this civil society. It is not because of civil society. We are complementing the efforts of government. We are raising the voice because when we raise the voice, we speak truth to power. Then the government will say, hey, something is wrong, let us address it. If we remain silent, we will continue. Now he's boasting that people are coming from the Gambia to do study tours. But if nobody raises the voice about the inadequacies within the judiciary, they will never step up. And we will just continue on that. And we will not be posting again that people will be coming here to do study tours to know about what is going on about the judiciary. Until somebody raises the voice and people look at it and they change, we move forward. Then you can see people coming now and giving us all type of accolades. And that is what we are here for. We are not only condemning, we are not only condemning, we are critiquing and providing solutions, making references, providing advices as to how we move. Even when we critique the judiciary that they are not doing enough, we are also asking the government that you need to support the judiciary. If the government is spending a lot of money on ACC, for them not to be corrupt, they need to spend a lot of money on the judiciary for them not to even attempt to even, when they are giving meaning to law, to see how they can look at, because if a magistrate or a judge is presiding, you are paying him or her, like let's just, or at least for the sake of discussion, you pay him or her like 5 million a month. And that magistrate or that judge is presiding over a matter of $200,000. My brother, the sensible currencies, we call them this US dollar, they put it, but just in your front. I will ask you, the accused person, what do you want me to do? I'm not saying, I'm just bringing something. But because the government is paying ACC plenty money that you don't need to, because that's why we are paying enough money, then I think the government also needs to do something. So you're saying
the judges and
they need to be well paid. Because if somebody is well paid, he or she will not be, be tempted, to undermine his or her own integrity.
As you raise that issue, let me ask Michael this question then. Earlier, you said more needs to be done in the judiciary. Well, I mean, there are reforms, there are good things. So what are some of those things that should be done, I mean, as a way of improving the sector?
Let me start by offering some answers to the issues raised by my...
By Alphonsus.
By Alphonsus, right? He has made some claims from Koinadugu and elsewhere. In law, as we know it, your case is as good as your evidence. If you say a politician is interfering in a given matter, back it with some evidence. If you can claim, you must prove. If you claim and cannot prove, your claim is an opinion. That's what the law will look at it. Again, let me tell him again. The issue about one being corrupt or not is all about integrity. That is why, in my estimation, the judiciary must recruit people whom they believe have carried themselves very well in the course of their practice and their life to adjudicate matters. Even if you give an individual billions of money, you understand? That does not stop a man without integrity from being corrupt.
I agree with you on that.
You understand?
But he mentioned, as you respond to him, he mentioned the issue of providing evidence, because definitely we know the burden of proof lies with...
If you claim you cannot prove,
so,
I'm afraid.
But he's saying that particular matter in 2019.
I've made reference.
This is a
so if you want to prove it,
this is a court of public
go to
opinion.
Kabbalah. I've given you the information.
This is a public court.
This is a court of public opinion.
You cannot ask me to give you the evidence. I have information.
And I'm the
I have
judge here.
evidence. I have witnesses.
I'm the
for
judge
the
here.
Koinadugu
I'm the judge here.
For bond, we presented the matter.
His objection is overruled. His objection is overruled.
The one for bond, the matter has been taken to the court.
No, his objection is overruled.
I am not dismissing, I am not saying his claims are not are unfounded. That is not what I'm saying.
Go ahead.
I am not saying these things he has just alleged are not the case. That's not what I'm saying. Okay? But I am saying if you want to add salt, pepper, and Maggi, or to make it, to be given the necessary credence, every claim must be backed with some evidence.
Of course.
Okay? As a right activist I've known for quite a long time, he has an established institution. You understand? He can always pick up issues with the appropriate authorities. Yes. Like he alleges that such a matter was withdrawn by the Office of the Attorney General. I am not having a brief. I'm not taking a brief for them. I'm not here to serve as PR for them. But the question is whether, as an individual, as an institution he carries or manages, whether he has taken up such an issue with the Office of the Attorney General.
But do you agree over time that particular power has been abused by that very office?
I don't have evidence to justify that.
There have been cases, there have been incidents where the Attorney General of this country would withdraw cases from the court.
But the law sanctions it.
That's what I'm saying.
There's a law. I'm
asking a question whether or not that particular provision has been abused. I'm saying yes, there's a law that provides for that.
Whether it has been abused or not, it's something that requires further evaluation.
Go ahead.
But the Attorney General can always, the General Minister of Justice can always ask for a matter to be withdrawn.
Agreed.
You understand? That is the power.
It's legal.
Whosoever drafted the law, the wisdom, whatever around that law, it is what it is.
So legal experts are now saying, in fact, that is one of the fundamental problems in the sector, because the Attorney General and Minister of Justice is a politician, and whether cases are against his political interest, those cases would see the light of day. But cases that are in his political interest, he would want to protect by exercising that very law.
Is the law.
That's what we're saying.
It doesn't matter how hard it is. It is the law.
Until it is set aside.
Until it is reviewed, repealed, or changed.
So do you think there is a need?
Until that law is changed.
Do you think there is a need for that law to be repealed?
You may want to know circumstances or the wisdom behind that.
In your estimation, what's the intent?
Let's assume.
Give us the intention.
It is the action is in breach of some other given law. For example, the Constitution says you cannot sue the president. okay? Whether it's civil or otherwise. There are other laws that says, especially for the State Proceedings Act, certain action you want to take, you have to proceed in accordance with the provision of the State Proceedings Act.
Right.
If, for example, some action has been commenced in some other courts without credence to the State Proceedings Act, the Attorney General will step in. So, I mean, what I think it's proper is to probably review such laws and give them proper safeguards so that they cannot be misused or misapplied. You understand? But I will not say it is proper to remove it altogether. That cannot be appropriate.
Okay.
Maybe we need proper safeguard. I told you, I have framed my discussion here into looking at the judiciary from what I call the hardware.
Yes.
I have said efficiently clear that from the facelift, the structure, the dynamics, the changes done, such as the recruitment of judges.
There have been
in everywhere you go now in this country, you have the presence of the judiciary.
That's a given. We've
That
given.
is good.
We've
That
given
one
the
is
judiciary. They've tried the hardware.
I call it the hardware.
Even accessing the Chief Justice.
Even accessing the Chief
It's
Justice.
open.
That is all hardware. It falls between
And
my
the software is the
coinage
most,
of-
it's the most
I'm talking
critical
about
part for
the
Minister Leone.
software.
Yes.
You understand?
That's a challenge.
And they are doing well, but I stated here that
More needs to
in
be
my
done.
estimation, the judiciary needs to do more. And I know even the PRO from the judiciary has not detached himself far away from that.
Yeah.
He has stated that they need to do more in the areas such as one. We have cases. I am from the Bar Association and I serve as public relations officer. We are working on complaints and we are trying to back that with data for your hearing. There are complaints. We have within the state, within the judges have time frame to deliver judgment, for example. Within the practice proceedings. I think it's 3 months. You understand? So if a matter has been completed and closed, waiting judgment, and a year has gone on, 2 years has gone on, it begs a lot of questions as to delivering justice. When we all know delaying it is denying justice.
Right.
Okay? We have complaints like that. What we are doing right now, as I speak to you, we have confronted ourselves as the bar executive to collect and identify those files and the judges before whom those files are, and pick up this matter with the Chief Justice. That is what we are doing. And that is what we intend doing in our own way to help the system work. Sometimes it is not the Chief Justice.
Of course.
The problem is not the Chief Justice.
Is there that carries the crown?
And if you ask the judges also, they may have an explanation for those things. You understand? Why matters are delaying, why judgments are not delivered. You understand? I'm a practicing lawyer too in Sierra Leone, right? I feel the pinch too. You understand? And we have complaints from our colleagues. You understand? This is the area I think the Chief Justice do not only need to, see it done, but to be part of the process to see that done. Luckily, my understanding is now is that they are taking track of every matter that is assigned through what is called case log or case book. You guys are internal management, so that they now know the number of files to this judge, how many files were assigned this year or this month. So they should have a track of files, how long this file has taken, what is the status of that file, has it been closed for judgment? If yes, when is it required for judgment to be delivered? Those things, I'm coming. It needs proper, those things. I want to speak to the PRO here and for the attention of all concerns that more is needed to be done in these areas, because if we close a case, for example, case is completed, properly adjudicated, completed, there are closing remarks. The file has been drawn for judgment. And for 6 months, 1 year, judgment has not been delivered. It's scary.
Agreed.
It's scary, okay?
Agreed.
That is the area, I think, one of the most important areas the Chief Justice needs to concentrate.
I'll come back to it so that we can look at the reformatory way forward in ensuring that we were able to sanitize the entire justice sector. But like you mentioned earlier, that the Chief Justice might not be the problem. sometimes is not the problem. If some of your colleagues within your fraternity, the law fraternity, some of your colleagues have advanced arguments that sometimes the problem is even the bar association, because you're expected to help the judiciary big time, but sometimes you're not proactive to raise certain issues so that they can be corrected by the judiciary.
We have done that quite a lot of time. Like I said, we are trying to do a similar thing I just told you, that with regards to complaints of backlog cases and delay in delivering judgments, we have entertained a couple of complaints and data information backing that, and we are trying to identify those kind of files, compile that, and we'll pick it to the Chief Justice, like we have always done in other areas, okay? Like I told you, the judges too will have the explanation for these things, you understand?
Right.
Sometimes, probably, a matter has been withdrawn, but some party needed to do one or two, take one or two steps, which are yet not taken. So the judges have their own explanation as well.
I understand that.
But we are saying, and I want to re-echo this, that the Chief Justice needs to, focus on his time and effort, in ensuring that judgments, especially those files that have been withdrawn for judgment, are delivered within time.
Okay.
You understand?
Elkas, this is very critical. How do we expeditiously deliver judgments, especially when cases would have been closed and it takes 6 months, 9 months, 1 year for judgments to be delivered?
I am happy you brought this up. Now, let me state this here. When he got appointed by His Excellency President Julius Maada Bio, there was a functional review, management and functional review, to ascertain the number of judges as per the number of citizens. When they did that survey, one judge attends to over 125 and more thousand Sierra Leoneans as at the time when he got his appointment.
Right.
Few years down the line, we appointed or recruited magistrates and more judges, and some judges deployed them. The number reduced.
So what's the ratio now?
Now, we have, as it is now, we have to a one judge. We have 93,317 citizens to a judge. So look at the gap. Africa
like the justice
ratio,
sector, like health sector.
Africa ratio is around 60,000. We are not even there yet. We are not even there yet. 93,317 citizens to just a single judicial officer. And even those that have been recruited in the provinces, I must state this, we don't have, vehicles are not available for our judges. The Honorable Chief Justice is making sacrifices just to ensuring that we administer justice, we operate in line with our constitutional mandate. That's just one. It's unfair to recruit judges or magistrates. Vehicles are not there. You send them to as far as Falaba district. You send them as far as Karine. You want them to go and sit court in Kwendu. You want them to go and sit court in Kono and beyond. Vehicles are not available. The enabling environment, courts are not there. If you go to Falaba, the very first day for us to commence sitting, the magistrates, the judge who went there on the criminal session, High Court criminal session, he sat in an open place. You know the danger surrounding that. And there were high-profile cases. You look at Kwendu. Kwendu, you need to go there and assess the place, look at the building that is very much enabling.
We have to let Alphonsus run along because he has some other engagement calling him now. But before we let you go, Alphonsus, what would you consider the way forward? What are the urgent needs right now for the justice system to be sanitized and for citizens to have trust and confidence in the system?
I think one of the things he has mentioned, we need to have, in the first place, the facilities for the judges and magistrates to do their job. At the bench, even in their courtroom. Like, we need computers, equipment for them even to be, let us stop this handwriting. One. The other thing is we also need to improve on their enumeration and logistics. These are the critical things. We are condemning the judiciary, but we have to also give, when somebody is a judge or a magistrate, let that person also have that, that pride that, yes, social status. That's really, I am a magistrate and I'm a judge. But you have judges, even accused persons are moving around like as if, we don't give respect. But we need to give respect to the institution. And the way how we also give respect to the institution, the government is the executive, the government specifically, is to commit more resources to upgrade the standard of our judiciary, the judges and the magistrates. Let them see themselves as part of a process. And let them have that pride. Let somebody be proud that, yes, I am a magistrate and I'm a judge.
And before he leaves us, let me say this. We canvassed or lobbied for 40 billion. Sadly, we did not get that. We only got the budget. Yes.
Yeah.
Look at the gap. Look at the gap. We requested or canvassed for 40 billion. How much did we get? 40. We got 15. So it was just can I say 1%, 14, now this 15. And we're talking about, we now have, with the current 2011 Local Court Act, local court is now under the direct supervision of the judiciary. We have those enormous responsibilities. We talk about administration of justice. We want to ensure we have judges and magistrates across every district. How do you take a judge to this particular place and there is no vehicle?
Let's quickly take a short break and we will be right back. All right, this is the holiday. Many people have to run around to ensure that the festive season is okay. So we have to let Alphonsus Bani take his leave. And I still have with me the Public Relations Officer from the Leone Bar Association, Michael Charles, and I have the the Director of Communications for Leone Judiciary, Elkas Sannoh, in the studio. So Elkas, let's get to it. Speak to the issue of selective justice Alphonsus mentioned, especially when he compared the 2019 case, which he said he followed up when the previous Attorney General was holding office, and at the end of the day, the pieces of evidence were in a file, but the file disappeared. But the same matter, Mohamed Kamarimba Mansari is standing trial, and he's behind bars for almost 2 years.
Selective justice. I don't have evidence for that so far. When I assumed this position, apart from ensuring that we create the enabling space wherein we have conversation around the judiciary by ensuring that we are very much accountable and transparent in our activities. But what is very much important here is that the Honorable Chief Justice is not averse to criticism. And when you talk about selective justice, this is the current Chief Justice. I could remember when we organized training for court registrars across the district, a national training for all court registrars. He was so bold to unearth those challenges. One of those things he spoke about was people jumping bail. And apart from the file missing, he told the registrars, he said, if that happens, you will get yourself to blame. We will set an investigation committee. If you are found guilty, you will not only be sacked, you will be punished. And we reported that. That is just to tell you that under his administration, he will not condone any form of indiscipline, non-selective justice, because he believes as long as you are a citizen of this great nation, you deserve justice. And therefore, to an extent that even when he thinks magistrates are not performing, it is his responsibility. He has been on their neck just to ensure they deliver. He said, I am here not only to defend the Constitution, but I am here to ensure quality service delivery.
You submitted earlier that no judiciary anywhere in the world is totally independent. And so the question now I want to ask you is, how much of a political influence goes into the work of the cell in judiciary?
Now, let me say this. I think I need to qualify that statement.
Go ahead.
Proper. What I meant in my submission was that we have fusion of responsibilities. In essence, therefore, it means the executive arm of government cannot work without the legislative arm of government. The judiciary as well. But it does not mean when it comes to performing its judicial function, it is tied to the dictate or being remote controlled by any of the two organs of government. It means the judiciary in the administration of justice or its judicial function, in the exercise of its judicial function, the judiciary is only answerable to the law or other acts, but it is not answerable to any individual. Any individual.
I asked that question because many advocates or activists have said the prolonged detention of Mohamed Kamaremba Mansari is politically influenced. And if that's so, then it's definitely through the judiciary.
Okay, let me say this.
Go ahead.
The former 2018 presidential candidate for the main opposition, All People's Congress, Dr. Samuel Kamara, was recently before the anti-corruption court on 2-count charges. And at the end of the day, he was granted bail. He was not alone. Among those who appeared before the court, one did not meet the requirements, the bail conditions. He did not fulfill the bail conditions. 3 days later, they came in with all relevant documents. So it means when there is this pronouncement, when a judge grants a bail, we are not talking about 99% fulfillment. It means total fulfillment, total compliance. And today, I must state here, very unambiguously, that if Mohamed Kamaremba Mansari fulfills those bail conditions set therein, there is nothing that will stop him.
His people have advanced argument that he has met his bail conditions. You are only making it difficult, and you are only keeping him through the master and registrar because of, the political games in the whole matter.
No, I just made a reference to Samuel Kamara and others who were granted bail and fulfilled their bail conditions. It was not 99.9%. It was 100%, means total compliance. If Samuel Kamara had failed to fulfill one of those bail conditions, they should have detained him. Nothing will have stopped that. But let me say this. Now, Mohamed Kamaremba Mansari sworn in an affidavit that I, Mohammed Kamaimba Mansari, he said he's Sierra Leonean and that he is not a holder of any other passport or any other document, traveling document, apart from the new Sierra Leonean passport that was presented, and on it we have a Guinean entering visa stamped on that passport. The other day, they brought in another one, that indeed he has traveled. But unfortunately, they cannot produce the traveling documents because, is it in 2018, the house where Mohammed Kamaimba was living got burnt down. And they could not produce that. But what they are failing to understand, is this. I could remember when we were at Frabe College, those years, a friend of mine had a problem. He did not take the exams because they said he did not complete his payment or whatsoever. So the registrar by them, SN Dumbuya, he went there, said, when you have reported that your house has been burnt down, there is always a certificate that should be produced by the National Fire Force.
Certifying that
exactly.
Indeed.
And
that was not provided.
That was not provided. In fact, you don't even need police report. Like they were saying, there was a day I was listening to one of the somebody who was saying here, is it a lawyer representing Kamarimba, that he has problem with the Sierra Leone police. They are still denying to present reports. You don't even need to go there. There should the fire force is there to provide you a certified true copy to ascertain the veracity of your claims, whether in fact it's true or not. So it's very much simple.
So as we try to round,
until and unless those conditions are fulfilled,
as we try to round up the conversation, 2021, what have been the major challenges of the judiciary?
Finance. We want support, financial. Yes, I cannot live here without also commending the government of Sierra Leone for being so supportive. But if you look at the quantum of developmental strides undertaken so far by the current Chief Justice, you will realize that there is need to provide more financial support to the Sierra Leone judiciary. It's unfair. People are talking about administration of justice, judiciary is not this, judiciary is not that. We have judges. How many have advocated for judges to have better condition of service? How many have advocated for magistrates to have better condition of service? How many have advocated here or come to tell Sierra Leoneans that, in fact, some of our judges are without vehicles? How many have advocated to call on the required institution to say some of our magistrates are without vehicles? But still, we are on the neck of the judiciary to work. We are doing it, but we need support. Go outside. We have deployed magistrates across every district now. But go, just take a tour across the district and see if we have courts in every district. No, the answer is no, but we want them to perform. You cannot perform when the required infrastructures are not there. You cannot perform when the environment is not enabling. When the Honorable Chief Justice assumed that position, judges were writing their judgments, sweating, they were perspiring in their office. He said, no, that is sad. In this 21st century, I cannot allow magistrates and my judges to write judgment in an environment, a dark chambers. That was so sad. That was sad. Now go to the chambers of our judges. The environment. He has sanitized the environment over the years. the place is just synonymous to any Abacha. People we are trading, doing businesses, hawking, all kind of business at the law court. The law court was a hub, but we said no. He said no. The law court, people should not see that meet around the law court. For say when you go there, now bad no more for the day. That is why, in just a week ago, we did what we call Christmas in the city to give hope to the judiciary staff, to repose confidence in them that I appreciate you. The Chief Justice believes he cannot do it alone. That's why now you are seeing awards, plethora of awards everywhere, including the Bar Association. And that award was presented by no less a person, but the first gentleman of the Republic of Sierra Leone, commending the leadership style of the Honorable Chief Justice. It means the current president is also pleased. And not only the current president, it means the Bar Association. Even though they are asking us to do more, there are challenges, but it means they are pleased so far at the magnitude of development, the quantum of developmental strides undertaken so far under the current Chief Justice.
Okay. Michael,
Yes.
what would be your parting shots with regard to what is expected of the judiciary, and how can we find a fine pathway for justice?
I have stated and also restate that the judiciary and the Chief Justice in charge has done so much. You understand?
Yeah.
But they need to do more. Okay, in the sense that I want in particular to take the Chief Justice to the under sheriff's office, the bailiff section in particular. Probably that is the other area. The Chief Justice or the Judiciary generally would need to concentrate their time. Okay? I think the only existing law, to the best of my knowledge, Captain of the law of Sierra Leone, which regulates the bailiff section. Okay? We have situations where judgment delivered by the court are always blocked. You understand? By the fact that the police who are supposed to aid the execution of such judgments, we undertake a mini judiciary as to whether they should execute or not execute. Quite recently, there was a memo on social media where the police was instructing, the Chief Justice was instructing its men not to undertake any execution. We are constrained to understand what exactly such a memo was about, because a judgment delivered by a judge, by a court of competent jurisdiction, should be executed if all required are being met. You understand? It does not lie in the hands of the police to say they will execute or they should not execute.
Should be carried out.
They should be carried out. So it's a frustration, especially at the part of the bar, because of what essence is adjudication if at the end of the day you cannot execute? We are still to have a very clear list of how much is required by way of money payable for execution in the bailiff section. These are concerns we are getting from the public. These are concerns we are getting from our membership. And it is, like I said, the Chief Justice has the will. He has done much. And he has the spirit to do more. You understand? Probably this discussion might open his eyes to other areas where improvements are needed. And one of those very important areas is the bailiff section. You understand? The judiciary is like a human being. The eyes, the hands, the feet. If one of these parts are not functioning, the whole being is not proper, or it might affect the other aspects functioning very well, especially when they deal with the end product of litigations, right? You have been in court, say, for 1 year, and judgment has been delivered. A poor litigant, for example, who has won a case, is required to pay some huge money before the execution can be carried out. Assuming that litigant cannot pay the money, but he has won the case, and the execution is not carried out.
So he still doesn't have
That's still to
justice.
undermine justice. You understand? And I am of the opinion, and I think this is the view of so many members of the bar, practitioners, that something needs to be done about the bailiff section. As we review the the Judiciary 2021, you understand? We're reviewing, commending, looking at what has been done, what, in our opinion, needs to be done. You know, what here Chief Justice have not paid so much attention and all of that. We have spoken about the divisions, the appointment of judges. We now have magistrates and judges everywhere. Structure is fine. There is quietness, decorum in the court building, especially where the Sheikh Stephen Street and all of that, you understand? But I want to state here again that attention must be paid in ensuring that there is speedy delivery of justice, speedy delivery of judgments, you understand? Especially for cases which have been completed and filed withdrawn for judgments, you understand? The Chief Justice in his office must put structures to also track those matters that have been completed and how long, or whether in fact judgment have been given to them, not so. And more importantly, like I stated, the office of the sheriff, the bailiff section. Well, I mean, there's nothing wrong to have in its reform the sheriff being a judicial person. Because when you make the sheriff a judicial person, a lawyer, he knows the meaning of a judgment of the court. He knows what is a stay and what is not a stay. And what must undermine or restrain the execution of a judgment. You understand? All of that. These are issues that are coming up. That we think the PRO of the bar, of the judiciary needs to
take back.
And probably take home and see how much is done in these areas.
Another thing I want to recommend
quickly
here is that when a matter is before a judge, the judge will always look at the evidence adduced before the court, and in delivering his judgment, it is always backed by or supported by law. Now, having stated that, what we also need is this: when you have bad laws, it's also a very huge challenge. So there is need for amendments of some of those laws. Or those acts. For example, you can't talk about, in this 21st century, we have Lasting Act 1916. You have the Sheriff Act. You have the Evidence Act. We talk about 1927. Our Supreme Court rules, is it 1985 or whatsoever? There is need to review those laws. In this 21st century, you talk about Lasting Act 1916. So these are all challenges.
Still go with our colonial laws.
How many people are coming to canvass, to advocate for review of those acts? But still they will blame the judiciary. They will not blame those who are making those amendments, who are failing to amend those laws. But still they say the Australian judiciary. But yet still we have the 1916 Lasting Act, we have Sheriff Act, we have laws that are far away about 1927, 1901.
Colonial laws. We still have our colonial laws, right?
So there is need to review. I hope the Bar Association also will champion that in ensuring that those laws, those acts are reviewed.
All right. Well, thank you very much. Quickly,
please. We are lawyers from the bar, okay? The law is the law, no matter how bad it is, okay? And we play around.
But if the laws are not progressive?
If the laws are not progressive, there are structures.
But would you
the judiciary is not working in isolation, okay? There's a judicial coordination establishment or so. You know, justice sector development. We have the Law Reform Commission. We have other operational appendages, you know, that are working together with the judiciary in achieving what you call delivering justice in this country. You understand? We are lawyers. You understand? No matter how bad the law is, it is the law until it is amended. We are saying what can be done under the circumstances to get things getting on. What Elkas is talking about, in my estimation, it's a long-term project. You understand? What can we do now? For example, he was referring to the Sheriff Act. You know, what can we do to make the office of the sheriff or the bailiff section a little opened and workable?
Are there low-hanging fruits in that?
Well, I do not want to say so.
Okay.
But what I am trying to say that there is much that is needed to be done, you know, because complaints are coming from there too. We speak with our membership, okay? This is clear. For example, what are the required fees?
Okay.
Per execution.
It's not stipulated in the law.
What is in existence is better we don't talk about. You understand?
Right.
What happens for a poor man who won a case but cannot
pay the fee?
Yes. Does that end his right to
His justice
fee?
drive, right?
So these are issues I think the Chief Justice, in my estimation, the Judiciary generally must also look into and see how they could also restructure or extend the restructuring and reforming of the judiciary in getting the things work, like I illustrated the human being. Every part has to be working to have a whole
system. All right. Well, this is where we end tonight's program. We say thank you to our guests for taking their time to come to the show. Michael Charles, the Public Relations Officer for the Sierra Leone Bar Association. Elkas Sannoh, the Director of Communications for the Sierra Leone Judiciary. And earlier we had Alfonso Bani from the Human Rights Defenders Network. We apologize for Barrister Ibrahim Tommy, Executive Director for Center for Accountability and the Rule of Law, not showing up. So we meet again next week, same time, same station, here on your home of all things credible, factual, and all times balanced news. The show has been a YV on Sunday, but if you miss this, a repeat of it comes up on Thursday at 10 p.m. Until we meet again, my name is Samuel Weisbango, and the show has been a YV on Sunday. Take care of yourself.